we get into the next session. And this session is going to deal with national data privacy and data storage. And to moderate that is Josephine Olok. Yeah, Josephine Olok, co-founder and director of Lumjo Consultants. Did I pronounce it right? Yeah, Lumjo. So please do come and introduce your panelists and let us off to the brilliant show of the early afternoon. So welcome, Josephine.
Thank you, Michael. Today, I have, and thank you viewers, esteemed guests, the Fintech community. I have a very distinguished panel with me today. I'd like to introduce Ms. Stella Alibatese. She's the director of National Data Protection Director at NITA Uganda. Stella, you're very, very welcome. Also on the panel, we have Mr. James Byaruhanga. Mr. James Byaruhanga is General Manager of Raxio Data Center. James, you're welcome. I also have Maxime Diodone, co-founder of Safe Border. Maxime, you're welcome. And then last but not least, we have Mercy Kainovwisho. She's the Registrar General at Uganda Registration Services Bureau. Mercy, you're most welcome. Thank you very much for panel members. As I said, it's an honor to be on this panel. Today we are going to discuss the National IP Policy, data privacy, and data storage. So we know the fintech industry is very much identified with innovation and creativity, and FITSTPA's vision and mission is to nurture the fintech environment and bring together the community to find sustainable solutions while creating an environment which stimulates that innovation but also best practice. So the challenge with the fintech community as we have it has been that many Ugandans are generating data and also IP assets, but they may not necessarily be aware of their obligation to protect that data or to be aware of the value of their IP assets and how they can go about protecting these. So today we will discuss the Data Protection and Privacy Act and the obligations under this act in protecting personal data, whether it's through collection, processing, or storage. We will also talk about the national intellectual policy, in creating awareness, and in protecting innovations and IP. So, Stella, you're welcome, and congratulations on your appointment. Perhaps you can tell us a little bit about yourself and your role at NITA Uganda.
Good afternoon, participants here and online. As introduced by Josephine, my name is Stella Alibatese. I'm a lawyer of 25 years experience. I've worked largely in the regulatory aspects within the public domain. And for the last 10 years, I've been responsible for developing an enabling environment for the IT regulatory environment. I was recently appointed the National Personal Data Protection Director, which role requires me to oversee the implementation of the Data Protection and Privacy Act. I'm a certified privacy manager, and I also hold GX certification in the law of data security and investigations. Thank you.
Thank you, Stella. Obviously a fantastic CV. James, would you like to tell us a little bit about yourself? Thank you.
Yeah, thanks. My name is Now? Okay. Yeah, I'm currently the General Manager for Rockshore Data Center, Uganda. I've got about 21 years experience in internet service provision, connectivity-related businesses, and recently more in data center business. Worked in Uganda and a couple of other countries, Zambia, South Africa, Ghana, all in a similar field, and I'm very much into internet protocol as a massive trendsetter in the life we're living now. I'm currently very curious about the fourth industrial revolution and how we're getting there as a country and as an industry. And I'm also very interested in seeing the explosion of the Savannah Valley, which is why I'm very curious to be in the fintech space and the fintech conference as well. And very proud to be sitting in this company here because I feel like I'm going to take some notes away. I think a lot of the things that are going to be discussed today play very much into the data center space. They play very much into the internet service provision space and more so play into the fourth industrial revolution. So I'm psyched to be here.
Thank you, James. I think we're all going to take away a lot from this discussion. Yeah. And congratulations on launching the first Tier 3 data center in Uganda. So congratulations.
Thank you.
Max, would you like to talk a little bit about yourself?
Sure, yes. Thank you, Josephine. So my name is Maxime Dieudonné. I'm the co-founder and co-CEO of SafeBoda. Okay, better now. So yeah, my name is Maxime Dieudonné. I'm the co-founder and co-CEO of SafeBoda. Previously, I worked in microcredit and corporate finance. So my background is more on the economic side. And then over the past 7 years, we've been growing SafeBoda from like a small startup to one of the major players when it comes to the startup ecosystem in Uganda. And so very excited to be on this panel and hopefully share some insights, on the evolution of certain trends we've seen in the fintech space, but also more specifically to this panel, the data privacy of our customer and how we deal with, the data that we collect and receive from our users.
Thank you, Max. I'm very interested to learn your lessons of how you do that. Mercy, please, would you like to tell us about yourself? Thank you.
Thank you. Yes, my name is... Thank you very much. My name is Mercy Kinowisho. I serve as the Registrar General at Uganda Registration Services Bureau, an institution that is charged with business registration, intellectual property, business rescue, insolvency and receivership, security, interest in movable property, civil registrations, among other registrations. I have 16 years of legal experience in business law and intellectual property, as well as leadership. And I have a passion for seeing the protection and commercialization of intellectual property in Africa and in Uganda specifically. And I'm happy to be part of this panel, and we're looking forward to this conversation. Thank you.
Thank you very much, Mercy. We're very interested in knowing what we need to do as a fintech community in terms of registering our patents and our innovations. So thank you very much for that. So this first question to Stella. I've lost track of my questions. So Stella, the government has recently released the data protection and privacy regulations this year, and your role is obviously part of implementing that regulation. What can you tell us about these regulations, and what should and who should know about them? Who should be curious about this?
Thank you, Josephine, for that question. Indeed, government in February 2021 released the data protection and privacy regulations. These regulations were necessary for the implementation of the Data Protection and Privacy Act. And basically, the Data Protection and Privacy Act is a law that regulates the collection, processing, and any other activity relating to personal data. Indeed, just like James, I'm happy to be here, given that James holds one of our biggest data centers, and Maxime has had a good experience in relation to data privacy, so I'm looking forward to listening to them. Now, I would like to give a quick overview of what this Data Protection and Privacy Act and regulations cover. I've already indicated what the brief overview of what the law intends to do, but the people it regulates includes any person, any organization that collects or processes data. And as fintechs, this is a very key topic because fintechs in many cases rely on analyzing and utilizing a lot of information. And in many cases, most of this information includes personal data. So I was very happy when this topic was put on the agenda. What we need to know is that the law provides certain rights to data subjects, and data subjects include citizens, residents, anyone whose personal data is collected. I think it's also important for us to know what is personal data, because that is what the law follows or regulates. Personal data is that information that can identify you. And this includes your name, your NIN, if you have a national ID, your passport number, sometimes even your residence, your location, anything that can be put together to be able to identify you as Josephine is personal data. And the law also provides for the obligations for data controllers and processors, and these include fintechs, because fintechs collect personal data before they provide services. What is critical to know is that within the Data Protection and Privacy Act, we have 7 principles that everyone must consider as they collect, as they utilize personal data. Some of these include, for instance, accountability. And accountability is in a sense of you being accountable for how you manage data, personal data within your organization. You're required to record, first of all, why you're collecting this data, who you're going to share this data with, when do you delete this data, what access controls do you have internally. So it is a whole procedural framework that you're required to have internally to be able to deal with personal data. The other principle I can talk about is the principle of transparency. It's very important that you are transparent in the manner in which you deal with the data. When I come for a service, for instance, from Uganda, they should be able to tell me why they are collecting that data. Their policy should be very clear to me. It should be in simple language. It should be accessible. It shouldn't be hidden at the back end of the website. So transparency in the sense, in the English sense, really, in the English word sense, that you have to open up. How are you going to utilize this data? What rights do I have in response, in regard to this data? How do I exercise those rights? All those issues should be very clear. The issue of security is very important. Once you receive this data, how do you secure it? And many other principles. It's difficult to really go over it, but I think what I can communicate to the fintechs is that make sure you know those 7 principles, and they are provided for in the Act. Whatever you do, as long as you map yourself against those 7 principles, you ask yourself the relevant questions, how am I complying with these principles? You'll find it very easy to comply with this law. Thank you.
Thank you, Stella. So it's clear that we have to have accountability for the data that we have, and obviously have transparency around that data. especially so that we don't fall afoul of NITA. That's correct, yeah? So thank you, Stella. James, you obviously, I don't know if this is the correct term, but you're a custodian of data, your data storage. How is Raxio supporting? And we obviously now are working in a very regulated environment. As you can see, we have our regulators here. How is Raxio supporting sector players to comply with these regulations to ensure that safety of data?
Well, I could give you a short answer and a long answer. The short answer...
A short one.
The very short answer is based on the type of data center we've built. So, just a quick overview of data centers is that there are different structures and different tiers. So, tiering is based on the level of availability you can provide to the customers that you have. For example, how much power uptime can you give? How many connectivity options can you provide to your service, to your customers? What's the cooling capacity you can give? And all those kind of things. Tier 1 is the lowest. Tier 4 is the highest. Of course, some are untiered, so to speak. We've built a Tier 3 data center and, of course, gone through the process of making sure that we can provide a service level availability that is Tier 3 capable. However, there's something very critical, and especially around data protection and privacy. We've built a carrier-neutral and cloud-neutral data center. This, therefore, means that Raxio itself does not provide connectivity to customers, neither does it provide cloud services to customers. What we've built is a co-location facility. So basically, the customer is in charge of his equipment and his data. We simply provide them with power and cooling and a secure environment so that they can be able to co-locate their data. Now, this was a deliberate effort. One is that it's a trend globally because customers want flexibility to be able to do anything and everything they want. But at the same time, is that it takes away, it de-risks the business from issues specifically around data protection and privacy, and these were lessons learned from most of the European carriers who are running into trouble with GDPR initially when it was rolled out. Now, how are we playing into the space and trying to help the sector? We also realized that part of the Act and the regulations points into the direction of sovereignty, which is basically being able to keep data in country. Data sovereignty is a big role. I mean, anyone who's following the Brexit, you saw how significant this was. So for fintechs and enterprises and financial services companies like banks, insurance companies, name it, anyone, any player, to be able to actually comply with the changing times in regulation, data sovereignty is critical. You need to be able to keep data in country, and the data and the data you keep in country should be able to comply with the regulations in the same geographical jurisdiction. The argument has always been we don't have anywhere to keep it. We don't have any facilities that are world standard to keep it. So we saw the gap, and we addressed this gap by building this facility. This is the first one. We're building a second one in a different geographical diverse area. Entebbe is high on the map for us, to be able to provide a home that people can use, one, for disaster recovery, obviously, because that in itself is very critical for business, especially fintech. You know you have to be online 24/7. For business continuity, every day, these days, we're no longer in a time where you can say, I've closed my shop. If you close the physical shop, you should be available online. But most importantly, to be able to comply with data sovereignty. So the facility is there for that, and we're continuously preaching the message that it doesn't make sense for you to waste so much time building IT infrastructure, keeping IT infrastructure, which is not your core business. Think about your core business. Take that pain away from us. Now, that does not necessarily say that we are looking away from the Act and the regulation and saying that it doesn't apply to us. Because our customers are data controllers and data processors. Most of the people that Stella is dealing with, she classifies any one of them in where do you fit in the puzzle, right? Some of the cloud providers are basically data controllers. and then there's anyone who's doing any analytics or doing any further application is a processor. But these are customers sitting within my facility. So, first and foremost, I must provide the right physical and logical security for my customers to be able to be safe. So they can't say that, listen, I couldn't actually do anything about protection because someone stole the server. As the data center, we provide 7 layers of security to make sure that every customer is safe. From physical security, boundary security, CCTV, road blockers, biometric access, you name it. It's a little fortress in there. But over and above that, we realize the need for compliance. So we've actually taken a decision to hire a compliance officer who will be certified in data protection as well, to be able to talk to the customers, guide the customers, make sure that we are actually reliant, including our own internal systems for our own consumption. Another thing that we saw as a trend in Europe was if you have a certified facility for data protection and privacy, people are more comfortable with it. So as soon as Stella gets her certificates ready, we will be in the queue quickly to make sure we have it in the gate, firmly planted there and saying we are certified for data protection and privacy, right? But maybe to conclude on the same issue is that some of the services that we want to provide in future, as Raxio much as we're a carrier and cloud neutral facility, is a service called Smart Hands. So some of our customers are so far away from the facility. They don't want to come there every single time they have to do anything. So they will call you and say, could you do maybe a restart for me of my servers? So that we call remote hands. But some others will say, I would like you to log into the server and be able to do ABCD. Not too much, but not too little, to be able to allow me to continue to operate remotely. And that's what we call Smart Hands. Now, when we launch the Smart Hands service, we are now getting into the space of data controlling, right? Because our guys are interacting with the actual hardware. So at that stage, we will have to make sure that we are fully compliant and fully trained and stuff. So we're taking all the steps forward right now to make sure the facility itself is secure, to make sure we have the right people in-house, to understand the Act. It's a huge document, well, and then they backed up with another huge document. It takes some time to read and understand fully, and then, of course, set some dialogue with Stella's office and understand. But mostly is that we've built a home for data sovereignty for the sector. People should have no reason to keep actually more than 75% of the members here keep their data in Amazon remotely. We're talking to the Amazons of this world, the Googles and the Microsoft, to bring the cloud here to be able to provide the same service, also talking to the local providers of cloud to be able to bring the same service and comply from a sovereignty angle as well. So that's kind of where we are.
Thank you very much, James. Yes, so essentially you're helping, you're supporting organizations, Fintech Community, to adhere to basically be compliant with regulation, but you're also going to get certified as compliant to the regulations.
Absolutely.
Okay.
Even just for good marketing, it's nice to be certified.
Okay,
It's
thank you.
a good thing to be compliant.
Thank you, James. Okay, so my next question is to Maxime. We know that you have a business which we talked about earlier deals with a lot of data, and we also know that you are now compliant with the data protection and privacy policy following ANITA audit. But first of all, can you tell us how you embed data privacy in your overall product strategy, and how do you reduce the chances of error in data management and privacy of customer information?
Yes, thank you, Josephine. We started SafeBoda 7 years ago, and I must say we've seen an extraordinary evolution, not only here but globally, on the topic of data privacy, the increase in awareness, and therefore the responsibility of companies like SafeBoda to comply with the highest standards. And so the way we look at it at SafeBoda, essentially we have kind of 4 layers or safe buckets that we look at. The first one is around the backbone of SafeBoda, like the actual like technical architecture of our technology. And there, like, it's making sure that our backend system that hosts customer data is well protected and regulated with different access, meaning that only certain employees that have specific roles can access that data. So that's like the first and basic principle for like any like company that deals with customer data, is having those access control in place. The second one is that we've mapped out kind of the risky areas in our backend and like looked at the endpoints that could expose customer data, and we've tightened security there. And we are ensuring that if like hackers were bad intentions, we have additional security on our like private networks. And then it goes without saying that trying to minimize as much as possible sharing data with like other parties, and when we do so, we review like carefully like the contracts and ensure we have like data privacy agreement with those parties. The second bucket, the second layer, which to me is probably even more important, is like the internal procedures and staff training. And this is like, the Data Protection and Privacy Act is fairly recent in Uganda. It came into action in 2019. And so, one of the aspect of it is like you need to have a data protection officer within your company. And so that's definitely like a recommendation I have for every, startups or fintech or entrepreneurs like that deal with customer data, just to make sure that you have someone in your company that is well-trained, aware of the regulation, is approachable, and people can reach out to whenever they have questions regarding data protection and privacy. And then obviously training your staff, and that's about like becoming obsessed about that, that aspect of the business, which is like we own information that is sensitive. And I must say, like, in all honesty, there's been an evolution. When SafeBoda was like, a small startup 7 years ago in our garage, like we didn't think the same way as we think today. When we are like a mainstream, application, and obviously like customer trust us to access this data. So that's really more like a mentality within your company, and be obsessed about these aspects. The third one is around the product that we built, and in making sure that the product itself is not exposing customer data. Like basics, like ensuring like a one-time password when you log in, having a PIN code for like areas of the app that are sensitive, like the wallets. But also, how do you think about like the transmission information within your product? And I want to take a quick example of the way we all do like peer-to-peer transfer of money. When you use a SafeBoda wallet, if you do a peer-to-peer transfer of money, we won't disclose the name of the recipient unless you give us access to your contact details and you have that person in your contact details. One thing I'm always shocked here in the way MNOs are dealing with peer-to-peer transfer is like, I can take any phone number and go to any mobile agent, and I will know the full name, first name and last name of the person. Well, I might not even know that person. And so we've been thinking a bit differently there to protect like the data of users, and we've put system in place so that you actually can't get the name of someone just by having the phone number. And then the fourth area is around the selection of partners. In certain cases, we need to work with like companies like James or other like data processors. And there it's all about like carefully reviewing the contracts, doing due diligence on the credentials of this partner, so that again we have a responsibility from our users to make sure we only work with professional and trustful companies. And I'm sure, as I said, it's an evolution. We'll discuss more about, the intervention that Nita, you had with SafeBoda, and all the learnings we got from that as well.
Thank you, Max. I think we're all keen to know how you did that, how you what the issues were behind that, and the learning lessons, I think, are going to be particularly important to the fintech community. I also think that it's good you've highlighted a certain gap in the with MNOs, but perhaps that's something that Stella could take up. So thank you for that. Mercy, as I said before, there are many innovations which are being built by fintechs in Uganda, but many may be oblivious to the need to register or patent these information. So fintech communities have a lot of IP assets. Can you tell us why it's necessary to register or patent these innovations, and what is the loss, or what do we lose out if we don't do this, if we don't patent these innovations?
Thank you very much. Indeed, it is important to protect the fintech innovations, but also general innovations. But before we talk about protection, it is important to appreciate the value chain of intellectual property innovations and the creativity elements. We appreciate the fact that there is creation of intellectual property by all kinds of sectors, the health sector, the education sector, the fintech, to mention but a few. And when you create intellectual property or generate intellectual property, the products and the investment matters. The prototyping, the testing, the product trials or the process trials, even to the extent of getting views or feedback on the brand, like Safe Border, as a brand name or as a system, is very key. So we look at that stage of intellectual property creation and generation. And as the National Intellectual Property Office, Uganda Registration Services Bureau does give the protection of these innovations or inventions or works of creativity. And when these innovations are created in the fintech industry or sector or whatever sector, there's a process that we take them through for protection. We wait to advise on the application, first of all. Is it registrable? Is it against public order, morality? Is it confusingly similar to what is already in our system, what's already protected? Is it eligible for protection according to the various laws of intellectual property and the intellectual property systems? The next stage, once we have given it protection, from application, registration, publication to registration, that is also the system of registration or the business process for registration. Once you have that certificate of registration, it is important that you go out to the marketplace and commercialize your product for utilization, for licensing, for any purpose that you want. The challenge is that we have generators of intellectual property in the area of fintech, but they never get to the stage of protection. They skip this phase of protection and go to commercialization. And by the time they come to protection, maybe somebody has already registered it or protected it or has something similar. And remember, on the intellectual property generation stage or creativity, co-creation, you've already invested a lot of money, a lot of research, or you have even a loan that you're paying for this generation of intellectual property. So after protection with Uganda Registration Services Bureau, the National Intellectual Property Office, it is important that you take it to the stage of commercialization. And when there's any infringement or piracy or counterfeiting, then you come back to us and we enforce your rights through our intellectual property enforcement unit that is manned by trained police personnel. So going back to the loss of not registering your rights or the benefits of registration, definitely registration is conclusive evidence of ownership. If any entity or any individual or any financier wants to engage with you, the first point to start on is, are you registered? Do you have a registration certificate? Or the issues of ownership and authorship, are you the owner or the author of these works? That is the first step of negotiation. The other is the fact that for you apart from the ownership and the registration from the National Intellectual Property Office, which is Uganda Registration Services Bureau, if you're going to transact in any trade, if you're going to trade across borders, you need to prove that you own this intellectual property. Before you go to the marketplace, the market space, there's need for that evidence of ownership. It is a bargaining tool for you if you have the registration in place. And we have also the system of security interest in movable property, the law that came into place in 2019 that enables you to use your intellectual property asset as collateral to access affordable finance. Many people look at the tangible property, the physical property, the land title, but the intellectual property title involves the certificate of either copyright, patent, utility models, traditional knowledge, geographical indications, and many others, or trademarks, is enough to give you a loan in the bank. Because they look at the brand, the value of safe border, for example, is so high that just the certificate of safe border should enable you to get a loan without even having a land title. So you miss out on those benefits. There's competition in the marketplace. It is a business strategy for you to protect your intellectual property. It is a competitive tool that you are in this market with many other players. We have so many players in the communication sector. We have so many players in the finance sector. We have so many players in the health sector. How do you distinguish your product from that of your competitor? It can only be achieved through protection within the various intellectual property systems that we have in place. Thank you.
Well, thank you, Mercy, for that. At least this is what my takeaway is going to be, that if I register an IP, I can use it as collateral.
Yes.
I think that is a big takeaway for me. But I also think it's a big takeaway that it's important to register before you commercialize.
Yes.
That obviously you protect yourself, you protect these things of people copying your ideas before you go to market. So thank you very much for that. That's very, very fascinating. So I encourage the audience, please, to be sending through their questions. Otherwise, we'll just keep talking and you will not be participating. So please send through your questions as I go through, as I keep asking the questions. I will be monitoring the questions. So a follow-up question to you, Stella, then is, so what does I know Max is going to talk about his compliance to data protection, but what does a compliant company look like to you? I mean, are there some indicators that we can pick up on and say, when you go to a place, you say that company is compliant? What should they be really trying to do? Because if you're going from non-compliance to compliance, perhaps it's a journey that needs to happen. But what would you say is a compliant company? Thank you.
Thank you, Josephine, for that excellent question. What would a compliant organization look like? First of all, this organization should have registered with the Personal Data Protection Office, because it's a requirement of the law that any person, any organization, any agency, whether private or public, that collects, processes personal data must be registered with the office. So the first thing that we look at is, are you registered? And if you're registered, there's a provision for a certificate. So that certificate should be either on your website or in your physical premises, maybe at the reception. The reason for registration, first of all, is for us to know who you are, what data you're collecting, and also to enable us support you comply with this law. So that is fundamental. I think it's important for me to also highlight that there are no thresholds. So you can't say that maybe I hold personal data for, let's say, 100 people, and because of that, I don't qualify. Right now, what the law requires is that whoever collects, so even James, Even James qualifies to register because I know Raxo has a staff, it has suppliers, it's collecting personal data. Secondly, the other aspect that we look at are your privacy policies. And we have policies internally, but we also have privacy notices that you're required to publish. Now, the policy is very important for us to do and to go through because it's one way for you to think about. It enables the organization to think about, for instance, what personal data do you collect? Why do you collect that personal data? What gives you the authority? Are you collecting it as a result of a requirement of the law, for instance, if you're because now that the fintechs are regulated by Bank of Uganda, I know there are certain KYC requirements that they must fulfill. So you need to go through that process. Is it as a result of a contract between you and me, who is a data subject? So those privacy policies enumerate all those reasons for you and document them. In developing that policy, you also need to to determine, once I have this data, do I need all of it? Because we have that principle of minimality. Only collect what you need. Only collect what you're going to utilize. Because remember, for any field of data that you're collecting, you must justify why you need it. For instance, if I go into a show, do they really need my name to be able to offer me a service? Maybe not, if I'm a one-time customer. If I'm getting a service or a good that requires a warranty, then they will expect my name and maybe my contact number. So organizations have to go through it. So when we come in, we want to see a comprehensive privacy policy. We want, I know some of the audits we've done, people also get these templates and just, accept them. So you read it and you find it's even referring to a company in America or something like that. We are encouraging companies to actually go through that process because it helps you when a data subject comes to exercise their right. It will also be very easy for you to respond because you'd have documented all these issues. The other issue that we look at is your privacy notice, because once you've done your policy internally, you have to communicate to the data subjects, those are the citizens and residents, why you're collecting this data, so that you give them information, and because of that, they will be able to make informed decisions. We'll look at, do you have a designated data protection officer? I listened in the earlier sessions, and we are all cognizant of the fact that fintechs do not have a lot of resources. And beyond fintechs, there are other organizations that are impacted by this law that don't necessarily have a lot of money. So that was embedded. While other jurisdictions require you to have a data protection officer, under the Data Protection and Privacy Act, you're required to designate. So you can even designate an existing officer to be able to provide you with these services. You do not have to hire an extra person. There are a number of things, but because of time, I think those are the key ones that we can look at. Thank you.
Yeah, thank you very much. I think those are well highlighted. Registration, privacy policy, privacy notice, and then designating a data protection officer. So thank you, Stella. So James, in your experience with managing data, how does it help when you're managing data? How does it help with the governance of say, your organization or the control of your organization?
First of all, Stella didn't tell us where we're going to register from. as we're going from here to registration.
I'll get that opportunity soon.
Okay. Thanks for that question. First of all, as cliche as it sounds, and I think the theme for half the conferences this year has always been around data is the new gold. It's really not that much. It's not really cliche. It's kind of relevant. And there's a thin line between data mining and data analytics. right? But a lot of very smart people have made quite a bit of business leaps by understanding how important data is. Now, as I mentioned in the beginning, I'm a huge fan of the fourth industrial revolution, and data centers play a huge role around providing a home for cloud storage. Cloud storage is basically the home for big data, and big data, of course, presents a platform to use applications for big data analytics, and now being able to present a business with an opportunity to make smart decisions. Now, as I mentioned, especially now that we're in a topic of data protection and privacy, there is a very thin line between big data analytics for business intelligence and being able to implement good strategic decisions and being able to position products and stay competitive. And of course, just data mining for whatever the purpose is, lawful or unlawful. However, the one thing we can't all run away from is that competition based on infrastructure is becoming less and less, right? And the growth and evolution of new technologies like blockchain is making it even more and more obsolete. So cloud, blockchain coming into play are taking away the infrastructure conversation in terms of competition. What's becoming more and more apparent is that data and data analytics are becoming the real tool, the real fighting position. How do I know my customer? How do I know how my business is performing? How do I know where I'm positioning my products? How do I know how to cross over, safe border style, from transportation to logistics, to e-commerce? How do I draw the line between my core business and other stuff? All this stuff depends on data analytics, being able to actually realize how to use it. Now, to your question, how many people why it's important to use data in your day-to-day business and being able to make the right business decisions aligned along data rules and data laws, and being able to know why you should store your data, just goes back to the principle of what is the competitive edge right now, what is actually giving one person an edge over the other, especially in this fintech space where in the beginning, all fintechs came from a VAS type company like value-added service providers doing some SMS stuff, then started slowly moving into SMS aggregation, mobile money integrations. Now they are full-blown platforms supporting agriculture, supporting transport, supporting food delivery, doing everything. But of course, as you know, there's a lot of overlap. So how does one compete with the other and beat the other, or better still, be able to stay afloat? It comes down to the data you have. The data you have from the market, the data you have about the products, the data you have around the competitors, or whatever you can imagine, and being able to extrapolate this data, build the right level of analytics, and be able to use it as your strongest weapon. So the edge and the area we're going into is that it's becoming very, very data-centric, and becoming less infrastructure-centric, that if you really want to stay afloat, you must be able to collect data, and I guess along Stella's guidelines.
Thank you, James. So data is the new oil, but it has to be. You have to.
You have to use it appropriately.
Appropriately.
Yeah. And of course, do your best to make sure it doesn't fall in the wrong hands, because then it becomes, black oil. Yeah.
Yeah. Thank you. So Maxime, I know this is. I'm very interested in hearing this story. You were recently audited by NITA. First of all, why were you audited? And then, what was the experience, and what have you learned from this to ensure compliance with the Privacy Act?
Great. Thank you for the questions. There's been a lot of discussion around that, especially in January and February this year. So it's a good opportunity to discuss it. So for context, there were allegations against SafeBoda that we illegally shared our users' data with a company called CleverTap. Following which NITAU started an investigation, and they spent over 4 months auditing our processes, reviewing who our external partners were, interviewing our staff, and obviously reviewing our policies. And so one of the conclusions from the investigation was that SafeBoda data privacy was not fully compliant with the Data Protection and Privacy Act of 2019, and mostly around the area that Stella mentioned of transparency. In our previous data privacy, we were just mentioning that we would share our users' data with data processors when we were required to do so to run our system. However, we're not specifically mentioning who those data processors are. And I think it's a very important point that Stella raised is how can we be fully transparent and truly explain to our users, okay, what do we do with your data? And so that was our main mistake, was not to specifically mention that we will share your data with that company called CleverTap. So stricto sensu, it was illegal because we were not fully compliant with the act. However, just taking this opportunity to mention, there was nothing malicious or abusive that SafeBoda was doing with the customer data. And as a matter of fact, we're still working with that company called CleverTap. It's now disclosed together with a few other companies, in our data privacy policy. What was unfortunate in all this story is how the mainstream media and social media appropriated the story and really try to portray SafeBoda as another Cambridge Analytics scandal. And so that's probably where there is, it's very important to raise awareness on these questions. And, we've learned a lot and became better on how we deal with data during all this process. And there is still a very important part of education that needs to happen for everyone to truly understand what we're talking about. So for us, that's kind of really how the main learning was how can we get better, and then how can we, as stakeholders here, really help on the education side to avoid having kind of, those misleading message when it's not justified.
Thank you, Max, and thank you for being so open about the experience. I think it's definitely a learning lesson for all of us, in making sure we remain compliant to the regulations. Mercy, perhaps I wanted you to just bring out the specifics that FinTech would need to know. You talked about registration before commercialization, but specifically, if I'm just talk us through briefly how to go about, saying that I have an innovation. How do I go about registering it? How do I know that this is something that's worth registering? How do I decide what is an IP and what do I need to register? Just briefly, in the interest of time, if you can tell us. Thank you.
Thank you very much, Josephine. Intellectual property is that property that is attributed to human ingenuity, the creative of the mind. And it has different categories. And so when these fintech entities, it is important that they determine or look at the products and processes that they are putting in place. There's a lot of innovation in as far as these technologies are concerned, and these innovations or works of creativity can be protected in the different categories of intellectual property. Intellectual property has mostly two components, the industrial property and copyright and neighboring rights on the other hand. And industrial property has also components of intellectual property. It has trademarks that protect the goods of one entity that distinguish themselves at that level. These are maybe logos, symbols, signs, scents, sounds, appearances, shapes, to mention but a few. So the trademark system protects the service marks in that categories, but also goods in that category. So the services and the goods, like Safe Border is a service mark, is a service because it's in the service industry. If Safe Border was a water for water, it would be a product because it is tangible, you can touch it. So that is the trademark system. Fintech can also be protected under the patent system if these are new, especially when computer programs, of course, are generally in Uganda protected under the copyright and neighboring rights law because they have software components and software systems, databases, and all that are mainly protected under the copyright system. But if they have the hardware component that involves a process to get to a product, then it is eligible to be protected under the patent system. And patents protect things that are new, things, processes that are, or innovations that are new that have not been done anywhere in the world. That is the novelty concept. And they must not be obvious to the person that is qualified or that is qualified in a certain area. If it is an engineer, it shouldn't be so obvious. The other element of patentability is that they have to be relevant or have industry application. Then there are utility models. They can also be protected as utility models, which are petty patents. They have lesser or stringent measures or incremental provisions for protection. They can also be protected under the trade secrets protection system, especially databases that have commercial value. If it is a database that has your clients, a list of clients, your client list, or information on the recipe or the business models or methods of doing business, or formula like for Coca-Cola, you can protect it under the trade secrets protection law. And this law has been with us for a long time. If you can also protect the fintechs if they have elements of ornamental or beautiful aesthetic designs, you can protect them under the industrial design system, which is under the Industrial Property Law of 2014. So this system protects the appearance of a product. Appearance, just the appearance, the beauty, the ornamental value of a product. And so all these fintechs can suit, they have an outfit where they can be protected under the various categories of intellectual property. But lastly, the copyright system that protects literary, artistic, and scientific works. So if a fintech has literary works, a documentation or a manual about how it works, its performance, and the literature is protected under the copyright system. If it has an artistic element in terms of a design or any appearance, even if it's a work of art, it can be protected under the copyright system. And under the copyright system, lastly, we can protect scientific works, and these are computer programs. So the fintech industry has a lot of ways of protection of the intellectual property. Thank you.
Thank you. That's really good to know. So we can really get protected in all areas. Thank you. So as we wrap up, we have two questions. One is for James, and I think this should be a yes or no answer, James. Does Raxio Data Center have any offers for fintechs and startups? Thank you.
Yes.
Thank you. Then to Stella. In a culture where people do not seem to understand the need for accurate data entry, what measures can be taken to ensure the right data is entered, for example, on application forms or by those that do data entry?
Thank you for that question. Indeed, one of the principles that I talked about in the law is quality. It's important that you have quality data. One of the ways you can ensure correct entry is by enabling the participation of the data subject. When you look at this law, the main rule is that you collect that data from the individual, from myself, from Josephine, from James, from Mercy. The understanding would be that if you collect that information from me, then it will be of good quality. Of course, once you collect that information, there should be a system that allows you to verify. And that is why you find, especially in the online space, before you accept a service, you're given that opportunity to go through it. Whether if you're doing online banking, whether you're registering on a new system, online you're always given that opportunity to verify. And I think that is one of the ways that you can do it. Thank you.
Thank you very much, Stella. So, and thank you, panel, for this very engaging discussion. I know we can talk forever, but time is not on our side. So I'll give you each a minute to leave us with your parting shots. So perhaps we start with Mercy this time.
Thank you, Josephine. I would like to emphasize the fact that intellectual property is an asset like any other asset. Intellectual property is intangible property, like you have your land title. And so you have to secure titles for intellectual property. And protection is very key in this whole game. And protection can take different forms. Through the National Intellectual Property System with Uganda Registration Services Bureau, you can protect your intellectual property through the Regional Intellectual Property System with the African Regional Intellectual Property Organization, where we're founding members as Uganda, and under the different protocols and treaties, you can secure your intellectual property. Then you can also register under the international system through the World Intellectual Property Organization under the different agreements and treaties and protocols. But the first thing is that you have to first register home. You register home within the national laws, and then you get the protection within regionally and internationally. So we encourage the fintechs that whereas you have very good products, our register does not have as much statistics as far as protection is concerned. We are also a data center. We have all this data of all registrations from businesses, intellectual property, civil registrations that have been registered with us since almost 1907. So please utilize our data and also be on the database of the country so that we plan for you better, so that we understand you better, but also we give you the protection that is deserving, and the cost is very affordable. Thank you very much.
Thank you very much, Mercy. Max?
Yes, thank you, and thanks everyone for the engaging panel. I would like to conclude maybe with a suggested action and jumping on one of the comments that Stella made around, startups or companies, copying data privacy or terms of use from, international companies. And I mean, that definitely happens. That's just the reality. And so the suggestion would be for FITSTPA to really help the members with like a toolkit when it comes to data privacy, because it's a complex question. It requires, a lot of legal advice. And so I think that would be like amazing for young startups, but even startups with like a few years experience to have additional exposure and tools to fully comply and to protect their customers.
Thank you very much for that suggestion, Max. I think it's something we definitely will take up. James?
So fintech space is generally that middle space between the telcos and the banking space, so to speak. It's the biggest disrupt sector in the country, and it's also the one that shows the most promise in terms of growth. You scare everyone, and I don't think it's by mistake. And I think it's something that should be held seriously, and we now need to start taking the fintech sector not in the geeky approach, not in the startup approach, not in I do the coolest stuff kind of approach, but rather that this is a massive pillar for the economy, and this is where we can actually change things. Nigeria and Kenya have already proven this, and the rest of Africa is trying to scramble to get into the same space. I think the fintech space is the place to be, and our data center has recently joined FITSTPA because we don't plan on missing the bus. My parting shot is that I think as an association, while you compete with each other as individuals, collectively you're driving this country forward, and I think I would like to pledge that we need to work together to build the ecosystem, to leverage economies of scale, and to be able to think through how we can dominate this space in Africa. So my parting shots is basically that let's take fintech seriously, and let's make the rest of the industry take us seriously. So that's it.
Thank you, thank you, James. And we are aware that you are still offering us good rates.
Always
Thank
the
you.
best in town.
Thank you, Stella.
Thank you very much, Josephine. First, I want to thank FITSTPA for this platform and for being here with these amazing panelists. I know FITSTPA is very keen on following up what is happening in the data protection and privacy space. They were one of the first organizations where we presented the Data Protection and Privacy Act when it was passed. Of course, now the regulations are out, so we need to come back. I also know that at some point in time, FITSTPA was working on a code of practice on data protection and privacy for fintechs. I'm interested to know how far you've gone. Please share it with us, because I think, I believe self-regulation is very important. We do this for the benefit of the customer, and we are all customers in our spaces. So if we can get compliance without necessarily having to draw out the stick, that would be very good. Lastly, because of time, there's a lot I could say about data protection. I think it's important for us and FITSTPA to work together to have deeper sessions that will provide more guidance to fintechs. We do have a website, www.pdpo.go.ug. Please go to that website. You'll find the registration forms. You'll have a guide. There are a number of guidance notes that we've issued. Obviously, we are still populating the content, but we intend to provide as much guidance as possible to make it easy for you to comply. We've already done a webinar to guide entities on how to register. You'll still find that content on that website. Thank you very much, and I look forward to more engagements with FITSTPA. Thank you.
Thank you very much, and thank you for the discussion, panelists. It's been a wonderful discussion, and obviously a very stellar panel. So thank you very much. Michael, over to you.
Thank you, Josephine. Thank you, Stella, James, Maxine, and okay. Let me not interrupt the cameraman. Multitasking, yeah. Josephine, you have done incredibly well and keeping this whole thing running. Stella, James, Mercy, and Maxine, we definitely appreciate your time and your sharing, and like I've learned, is that the willingness to share is the only way you get to learn from each other. So we truly appreciate it. Just let you know that Josephine Olok is also a member of she sits on the board of FITSTPA, And so moderating this session was definitely added value. So we're going to have a 20-minute break, and the intention is to have you go grab some water, grab something to bite, and then in 20 minutes at exactly 1:30, the next panel session that is already here, ready to run, is going to be in motion. And with that, allow me to also invite you to visit the different booths that are already up on the platform. Visit, interact, and make acquaintances with all those that are participating online. With that, enjoy the break, and we come back here at exactly 1:30. Thank you.